Okay, we are on the record for Wednesday morning civil docket, June 9th, 2021. I'll take quick announcements, please. Please use a reaction button. Ms. Love?
Good morning, Your Honor. I have F 221321-9 in the interest of Keilani Itzel Fuentes, Caitlin Marie Fuentes, and Kylie Emily Fuentes. Your Honor, we did turn in a temporary orders and suit affecting parent-child relationship. We e-filed it on June 6, 2021. It's been signed off by attorneys and all parties.
Okay,
I just don't know if the court would need us to prove it up, or would the court just accept it like that? I don't know what opposing counsel is on.
okay. I did see, I think, opposing counsel. Mr. Ramos, are you on? Okay, I don't have an issue on temporary orders to sign them. If it's signed off by all the parties, I'll ask for it to be forwarded to my queue.
Okay, thank you.
Okay,
I have no further business. May I be excused?
you certainly may.
Thank you.
Yes, Attorney Rogelio Garza?
Good morning, Your Honor.
Good morning, sir.
Opposing counsel is Tara Kern. She is in the meeting. And we have a status hearing. We're set for a mediation on July the 15th with Attorney Alfred Denham.
Okay. And what is the case number?
That would be CL-19-3533-I.
Okay. And the mediation is set for what date?
July the 15th, Your
Okay.
Honor, with Attorney Alfred Denham.
Okay. Any additional announcement by opposing counsel?
No, Your Honor.
Okay. Okay, then we can come back for a second status to see how you're doing on mediation, if it's settled at mediation, I'm sorry.
Sure.
And what direction you want to go after that. And we can come back on September the 8th.
At 9:30, Your Honor.
Yes, sir. And that'll be your second status.
Thank you very much, Your Honor.
Okay, anything else?
No, we may be excused.
Yes, you may.
Thank you.
Thank you.
Ms. Salinas Anzaldúa?
Yes, Your Honor. I have an announcement on number 16 on your docket.
Okay.
Opposing counsel is J.R. Garza, judge, but he's in the middle of a mediation, judge. I do have a Rule 11 agreement that I'm planning to go ahead and file, but we're agreeing to go ahead and extend the temporary ex parte order. And we're asking for a setting in August.
Okay. August 25th,
Thank you, Your Honor.
and that'll be at 9:30. And just forward the extension. Once it's filed, the extension will be forwarded to my queue and I'll sign off on it.
Thank you, Judge.
Okay? Anything else?
Judge, I do, but I don't see opposing counsel on the other case, Judge, so I'll just wait.
Okay. Do you have permission to make the announcement, or is it going to be contested?
I do not know, Judge. I reached out to him yesterday, but was not able to speak with him.
Okay, got you.
Thank you, Judge.
Okay, then just come back, either come back in or you can just wait, up to you. Okay. Attorney Brandon Holobar?
Morning, Your Honor. How are you?
Good morning, sir.
Your Honor, I'm out of the office, so I don't have a tie, so I'd like to be able to appear without one. I apologize today.
No, that's fine. Go ahead. You have
Your
a
Honor.
jacket. That's more than what some attorneys show up with.
Your Honor, I have number 6 on the docket, F 3406-20-9. It's a pro se divorce. We represent the respondent, Melissa Reyes. I believe Mr. Reyes and Ms. Reyes are here. Also is Eddie Moya from Gonzalez Castillo Moya. I worked with the firm when we filed the counter petition, but I don't anymore. So I believe Mr. Moya was here just to make sure that that firm was taken off. as the attorney of record.
Okay, so then I'm sorry, you're substituting in, or that was when you were at,
Correct. I'll be keeping the file, and actually it's a simple prove up today. So there's the parties are in agreement. The only thing after today will be submission of the agreed decree.
okay, no problem. Okay, Mr. and Mrs. Reyes, can you announce yourself, please?
Yes, Your Honor, present.
Okay, and Ms. Reyes? I see her. Ms. Reyes, can you hear me? Okay, you're not connected to your audio. Can you please connect to your audio?
Can you hear me?
Now I can.
Oh, okay, there we go.
Okay, Mr. and Ms. Reyes, can you please raise your right hand? Mr. Reyes, you're not on camera. If you can turn your camera on, that'll be helpful. There you go.
There you go.
Okay, please raise your right hands. Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Okay, Ms. Reyes? Okay, Mr. Holobar, you may continue.
Okay, I just very briefly, Mr. Reyes, you filed the petition for divorce in this case, correct?
Yes, correct.
And all the information in that document is true and accurate, correct?
Yes, sir.
Okay, and you were married to Ms. Reyes on September 7th, 2012,
Yes, sir.
and you all separated approximately February 8th of 2020, correct?
Yes,
And both you and Ms. Reyes are requesting this court to grant you a divorce today, is that right?
yes, sir.
Okay, and even though you're pro se, you and I've had multiple conversations with Ms. Reyes, and we've discussed this matter, correct?
Correct.
Okay, and what we will ask the judge to do today is based on the agreement between you and Ms. Reyes, correct?
Okay.
You cut
Okay.
off Mr. Holobar.
Oh, I'm sorry. Mr. Reyes, what we're going to ask the judge to grant, it's by agreement between you and your wife, correct?
Correct.
Okay, and the marriage has become insupportable, and there's no chance at reconciliation, is that correct?
Yes, correct.
And in this marriage, you all had two children, Aiden Michael Reyes, date of birth 1/5/2014, correct?
Correct.
And Aaliyah May Reyes, date of birth 8/15/2019, correct?
Correct.
And it's my understanding you all have agreed to be joint managing conservators with your wife, designating the residency of the children. Is that correct?
Yes, sir.
And you're going to have extended visitation, correct?
Correct.
And currently you're in the military and based out in Hawaii, but you're going to be coming stateside soon. Is that right?
Yes, sir.
Okay. And regarding child support, we've discussed that and you've agreed and asking the court to pay the presumed 25% of your income, which we will put into the decree, correct?
Correct.
You also will be responsible for the health care of the children, which will be done through TRICARE, right?
Correct.
And regarding property, there's no community property and separate property between you and Ms. Reyes, correct?
Yes, that's correct.
And any all debts that you all have, you're going to be paying those. Is that correct?
Yes, sir.
Okay. And regarding the possession schedule of the children, do you believe it's in the best interest of the children for that kind of designation and visitation schedule?
Yes.
Okay. And the division of the property, do you believe that's a just and right division?
Yes.
Okay. Your Honor, that would be all the questions that I have for Mr. Reyes, and just have one or two for Ms. Reyes.
Okay, you may proceed.
Ms. Reyes, we filed a counter petition, and everything we stated in that document is true and accurate, correct?
Your audio is off again, Ms. Reyes.
There.
Yes.
I don't know the
Okay,
term,
Ms.
but
Reyes, in the document that we filed, the counter petition, all the information is true and accurate, correct?
yes.
Okay, and the only children that you have with Mr. Reyes are the two that we talked about, and no other children are expected, correct?
Correct.
Okay, and regarding the children, you believe that's the best interest of the children regarding the schedule that we had talked about? Yes?
Yes.
You have to say
You
yes.
need to be verbal.
Okay, and regarding the division of the assets, you believe it's a just and right division, correct?
She's having problems with her audio, but she did say yes.
Okay, and lastly, Ms. Reyes, it's my understanding you want to change your name back to Sawuseda, to your maiden name,
Yes.
correct?
Yes.
Okay, you're also asking this court to grant you a divorce, correct?
Yes.
Okay. Your Honor, that's all I have. I'd like permission, maybe 14 days to prepare the decree, get it up to Mr. Reyes for review and signature.
Okay. The court will grant your divorce and the relief as requested, and it'll be set forth in further detail in a divorce decree that is to be submitted to the court by June 25th. And that should be signed off by all parties.
Thank you, Your Honor. I believe that's all we have.
Okay, Mr. Reyes, thank you for your service. Ms. Reyes, both of you, best of luck to you. And like I tell as many people as I can reach, co-parenting is a special art that takes both of you. At the end of the day, your children are your only legacy that you should care about, that you leave in this world. So to have them healthy and adjusted during this time period should be your top priority. So
Yes, Your Honor, thank you.
I commend you for coming up with an agreement and not dragging on this litigation. And I do wish you the best of luck.
Thank you.
Okay,
Thank you.
all
Can I be
right.
excused?
Yes, you may.
Thank you, Your Honor.
Attorney Willie McKellen.
Good morning, Your Honor. I also apologize. I'm in my truck. I wasn't able to get to the office. I thought this case was taken care of. I have number 17 on your docket. It is CL 15-1708-I, Israel and Marta Sanchez versus Standard Guarantee. This is a case that the court had sent to mediation with Daniel Hernandez. However, before we were able to get to mediation, we did resolve the claim. I filed a non-suit on April of this year. However, there wasn't an order filed. So I spoke to the court this morning and we did file one this morning for the court signature. So
Okay.
I spoke to opposing counsel yesterday. I don't know if he was going to make it online, but he allowed me to make this announcement without.
Okay, then I'll look for the order on the non-suit and I'll have it forwarded to my queue for my signature.
Thank you, Your Honor. That's all I have before this honorable court. May I be excused?
You certainly may.
Thank you, Your Honor. Have a good day.
Thank you. Attorney David Rohrig.
Good morning, Your Honor. I am here on CL 20-1808 dash, well, it used to be B, now it says I or 1. James Edward Munoz and Martin Paredes versus Vladimir Ehibia. Mr. Paredes is not my client. He's an intervener, but Mr. Munoz is my client. We have resolved his claims against the defendants. We filed an agreed motion to dismiss. But I think what needs to happen is I need to get with defense counsel and ask them to amend that motion to dismiss and add a motion to sever so that our portion of the case is completely final. But the court wanted us here at the hearing, so perhaps the court has another concern.
Okay, give me that case number again. I don't see it on my docket.
I apologize, Your Honor. I looked at your court's website, and couldn't find your docket. It's CL 20-1808-I. I can't tell if it's a 1 or an I. I think it's an I. James Edward Munoz, plaintiff.
Okay, yes, we're I. Okay. And opposing counsel for today's announcement is who?
Allison Logan.
I'm here, Your Honor. And I would be more than happy to amend the dismissal documents.
Okay,
That makes sense. And
Okay.
we're
The
still,
court had another concern.
I needed just to make sure it's cleaned up, that's all. Okay, so when is, how much time do you need to get that done?
we probably can do that by the end of the week. Get that to
Oh,
you
okay.
out.
Okay. So then that'll conclude your portion, correct, Mr. Rourke?
Yes, Your Honor, and the intervener has separate counsel, so I would just have to look forward to my next filing in this honorable court.
Okay. Then what I'll do is I'm gonna go ahead and still, for the remaining parties, set that for a status hearing.
Okay.
And I'll set that for August the 25th.
And we're negotiating, Your Honor, and most likely we'll mediate the matter.
Okay.
Thank you.
Well, just let me know where we're at on that date.
Yes, ma'am.
Okay. Thank
That's all I
you.
have before the court. May I be excused, Your Honor?
You certainly may.
Thank you for your time.
Thank you, Judge.
Thank you. Okay, Attorney Michael Tuttle.
Good morning, Your Honor. I have number 9 on the court's docket, which is CL 17-3055I. Opposing counsel in this case, Your Honor, the court had excused him at the last hearing. This is a motion to withdraw. We have given proper notice to my client with regards to that motion to withdraw.
Okay, on CL 17-3055-I, Madi Shaheen versus South Texas Educational Technologies et al. Anyone else here on that case? Okay, Mr. Tuttle, the court will grant your motion to withdraw on this matter.
Thank you, Your Honor. I believe I had submitted an order with my original motion, but if the court needs me to submit another one, I'd be happy to.
I'll request the order granting to be forwarded to my queue. Now, what I will, do you know if your former client will be retaining new counsel?
My understanding, Your Honor, is that they've had some conversations with Keith Live saying he'll probably be making an appearance in the case, although I haven't seen that appearance yet, but that may be forthcoming.
Okay, well, if you can please give him final notice that August 25th will be a status hearing
August 25th, I will, Your Honor.
at 9:30.
Yes, ma'am.
And I believe Mr. Lifesay is here on another case, so if he heard that and he does come on.
Judge.
Yes.
At the previous hearing, we had set a status for 8/16 after Mr. Tuttle's motion to withdraw today.
No, we're moving it to August 25th. Yeah, okay. So anything else, Mr. Tuttle?
No, Your Honor. May I be excused?
You certainly may.
Thank you, Judge.
Thank you. Attorney Claire Portis?
Yes, Your Honor. I am here on one case at Bank of America. It's number 20 on the docket, Bank of America versus Gabriel Cadena. We filed a motion for default judgment on this. Defendant has been served. I'm assuming we just need to get an order setting hearing on file.
Okay, that is CL 174843-I, Bank of America versus Gabriel Cadena. Is Mr. Cadena present? Okay. If you've already filed your motion for default judgment, that's just file your order setting hearing and we'll get that set.
Yes, Your Honor. We'll do that. That's all I have for this morning.
Okay. Now, are you going to be doing that soon?
Yes, I'll make sure it's done in the next few days.
Okay, I'm gonna set a tickler for that on June the 25th to see if it's been done, because if not, I'll lose it.
Yes, Your Honor.
Okay.
Thank you.
Thank you. Okay, Attorney Melinda Diaz.
Good morning, Your Honor. I am with Mr. King. We're number 5 on your docket. It is a prove up on a divorce, Your Honor.
Okay, F3372-17-9 in the matter of the marriage of Ricardo Sierra versus Sheila Torres.
Your Honor, this is John King. We're ready and we are the petitioners and ready to prove up.
Okay, and Mr. Sierra, are you present?
Your Honor, he is in the square that says King Law Firm. He's in our Zoom room.
Okay, and Ms. Torres, is she present?
She is, Your Honor. She's in the square that says Oliveros iPad.
Okay, so Mr. Sierra, can you hear me, sir?
Yes, I can do, Your Honor.
Okay, Ms. Torres, can you hear me, ma'am?
Yes.
Okay, can I please have both of you raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Ms. Torres?
Yes.
Okay, you may proceed, Mr. King.
Thank you, Your Honor. Mr. Sierra, would you please state your name?
Ricardo Alejandro Sierra.
And you are married to Shaila Cardiel Torres?
Yes,
And at the time we filed this petition for divorce, you had lived in Texas for at least 6 months and Hidalgo County for at least 90 days.
that is correct, sir.
Thank you. You and Ms. Torres were married on August 13, 2006, and you ceased to live together as spouses on or about December 10th of last year. Is that correct?
That is correct.
And would you say that your marriage has become insupportable due to conflict or discord of personalities that destroys the legitimate ends of the marital relationship? Or in simple language, has your marriage gotten to where it no longer works?
That is correct, yes.
Is there any way that you and your wife can get back together and make it work?
No, sir.
So you're asking the court for a divorce.
That is correct, yes.
And of the marriage, you had one child who was born, and that is Gia Sierra, 12 years of age.
Yes, sir. That is correct.
You had no other children. You have not adopted any children, and your wife is not presently expecting. Is all of that true?
That's true.
Okay. And there are no other court-ordered orders with regard to the child, no conservatorships, guardianships, or any other matter.
There's not. No.
Now, you and your wife had entered into what the court calls a parenting plan, in that y'all have agreed that you will be joint managing conservators of your daughter, that your wife will establish the primary residence of the child within Hidalgo County, Texas, and you will have expanded standard visitation. Is that all what you have agreed to as to the access and custody of the child?
Yes.
And with regard to child support, you've agreed to pay the sum of $863.02. I know that's an odd number, but that's the calculation per the code, 863.02 on the 15th day of every month starting June 15th. Is that correct?
That is correct, yes.
In addition, your wife has insurance directly through another source, and you're going to pay medical support to her in the amount of $239 each month, and cash dental support in the amount of $79 per month. This will also be on the 15th of each month. Is that what you've agreed to?
Yes, that's what we agreed.
And I think you also agreed that anything that's not covered by medical or dental insurance will be divided 50-50 between you. That means copay, deductible, and items like eyeglasses that are not covered.
That is correct, yes.
Thank you. And with regard to the division of the property, you've agreed that you're going to take over the payments on the house at 820 Cimarron Drive, and that your wife will deed her interest in that property to you. That you'll own the household furniture and effects other than the items awarded to your wife. You'll keep all clothing, jewelry, and other personal effects and sums of cash in your possession. That you will get the 2017 Chevy Silverado along with the debt, and that you will have the membership interest, meaning the ownership interest in the company known as Sierra and Sierra Consulting, LLC. Is all of that correct?
That is all correct, yes.
And we're confirming that the 2005 Chevy Silverado was and is your separate property.
Yes.
Now, you have already provided us a cashier's check in the amount of $10,000, which you're going to be paying to your wife as part of the community property division. Is that right?
That is correct, yes.
Okay, so you will owe all debts that you've incurred since separation, the mortgage on the house, the balance due on the motor vehicle, and any other debts in your name. Is that correct?
That is correct, yes.
Now, your wife has a list of property that's set out in the divorce decree, beginning with the dining table and ending with the 55-inch Samsung TV. Have you agreed everything that's in the divorce decree? Is that your agreement as to what your wife is taking, along with the $10,000 cash you're giving to her, the 2018 Mercedes-Benz, upon which she assumes the debt, and the proprietorship in her business, Skin Care, Shaila Cardiel, together with everything in that property, in that business?
Yes, we agreed to own the list, yes.
Okay. And of course, she will owe the debts on her car and any debts or obligations she's incurred since your date of separation.
Yes.
Now, do you believe this is a fair and just property division?
Yes.
Now, you and your wife have both signed a decree of divorce that sets out that division and makes each of you responsible for your own attorney's fees and court costs in this case. Did you sign that decree of divorce?
Yes, correct. Yes, I did.
And we have submitted that in queue to the court, meaning that it's lined up for her to sign. Are you asking the court to enter that divorce decree?
Yes.
Your Honor, I would pass this witness.
Ms. Diaz?
I have no questions of Mr. Flores, Your Honor.
Okay,
Yeah.
and of your client?
Yes, I do. Shyla, good morning.
Good morning.
You heard what was read into the record?
Yes,
You heard everything that Mr. Sierra testified to,
yes,
and you're in agreement with that?
yes,
And you had an opportunity to review and make any changes or corrections on the final decree of divorce before you signed it?
yes,
And again, your signature appears and you're asking the court to approve it?
yes,
And you believe that the division of the community property is a fair and just division?
yes,
And you also understand that the possession and access that we've asked the court to order is in the child's best interest?
yes,
Have you been satisfied with my services and my advice?
yes,
And you're asking this court for divorce?
yes.
I have nothing further, Your Honor.
Your Honor, in addition to the signatures of the parties, both attorneys have approved the decree as to form, and we request the court to enter this decree and grant this divorce.
Correct, Your Honor.
The divorce will be granted and the relief that has been testified to will also be granted, and anything that set forth in further detail in the divorce decree signed off by all the parties and the attorneys will also be signed off by the court. I wish you the best of luck, Mr. Sierra and Ms. Torres, and I commend you
Your
for
Honor.
coming to an agreement, especially with respect to your child, who should be your only priority at this point. So co-parenting is a tough job, but you can do it, and you've already taken the first positive steps in making
Yes.
sure that your child has a secure and safe environment.
We
So
will.
I wish you the best, and God bless and take care.
One more clarification, if I may, Your Honor, before we leave. As Mr. King said, there is a check waiting for my client at his office, and I believe she is also to sign over a special warranty deed when she picks up that check, just so that those parties are aware of that.
Yes, we're going to exchange the deed for the check, Your Honor.
Okay, no problem.
Thank you, Your Honor.
Thank you. I have a message on the chat from Alexi. Alexi, what is your case?
Oh, we may be excused.
Yes, you may.
Okay, thank you, Judge.
Alexi?
Judge, I believe that's my client, Alexi Ramos. We have a hearing today, a final hearing on a motion we've had on file for a bit. And Sergio Sanchez is the attorney opposing counsel on the case. This matter has been recessed.
Okay, so you're waiting for Mr. Sanchez?
Yes, Judge. I mean, I've been checking regularly to see if he's logged on, because this is what this is supposed to be an agreement. We've been represented too by Mr. Sanchez that the property being held by Lorena de la Garza was going to be refinanced, and we have yet to receive any confirmation of that, Judge. And so I asked my client to make sure he attends, and I'm sure he's got work commitments. So I'm waiting patiently for Mr. Sanchez right now.
Okay, and Ms. De La Garza, is she present?
I did not see her name as I scrolled through the list, Judge. There are some unidentified instruments. I don't know whether the court wants to announce her name to find out if she's present.
Okay, Lorena de la Garza, are you present? Okay. Well, Mr. Guerrero, I'll give you an opportunity to contact Mr. Sanchez's office. I can also recall you at 11. I have another docket at 11. So
Okay, well,
you can just let me know what you want to do.
I'll make a call right now, see if he'll get on. Thank you.
Okay, thank you. Okay, Attorney Gracie Orellana.
Good morning, Your Honor. We have number 25 on your docket.
Okay, CO 192929-I, Xochitl Rivera versus Gina Martinez.
Good morning, Judge.
Graciela Orellana.
Jesus Hernandez for the defendant.
And Graciela Orellana for the plaintiff.
Okay, and what is your announcement on the status?
Judge, on this one, we're just needing a trial date. Based on my notes, we've completed discovery. It looks like we mediated back in January of 2020. However, there's no new information that I can provide opposing counsel that would help us reach an agreement on this one.
Ms. Soriano, I believe this is one that we also had that informal settlement conference on back in March.
Right, we did.
And we've tried twice, Judge. We haven't been able to settle.
Okay, so then let's come back then on September the 29th. And by then I should be able to give you some dates so we can get you on the trial docket. And I'm gonna set it for a second status at that time, but we'll see where we are with the trial docket.
Okay, Judge.
Very well, Judge.
Okay, anything else?
I have nothing further, Your Honor. I've excused.
You certainly may.
Judge, I have
Thank you.
an additional case on the docket.
Okay,
That would be number 19, Gonzalez versus Chen.
okay, CL 154397-I.
Sergio Munoz is on the other side, Judge. I haven't seen him log on. However, we do need to discuss this case. It's a very old case. And we've been trying to get plaintiff's deposition for some time now.
Okay. And well, I know that Mr. Munoz was in session, so I'm sure you weren't able to do anything during this time period. Have they given you any dates?
Not at all, Judge. That's the problem. We've reached out several times.
Okay,
Court to order deposition within 60 days of today's date.
well, I'm not gonna do that without him being here and seeing what
Obviously, yes,
what his
Judge.
position is, but what I can do is if you'll be on standby, I'll have my staff contact Mr. Munoz to see if he'll be appearing or if he has somebody appearing on his behalf. So if you'll just wait momentarily and I'll recall this case.
I'll be on standby, Judge.
Thank you.
Thank you.
Okay, Attorney Kevin McGuire?
Your Honor, I'm here on number 14.
Okay, I can barely hear you, sir.
Okay, I'm sorry. Can you hear me better now?
If my court reporter can hear you, I'll let you continue. Okay.
Okay.
So it's CL 210209-I Ford Motor Credit versus Artemio Chapa.
That's correct, Your Honor.
Okay, what is your announcement, counselor?
Ready for our motion for default judgment.
Okay. And I see that, so you served them by service substitution?
They were served on March 29th, 2021. We do not show an answer on file.
Okay. And was the return filed?
Yes, I believe it was.
Okay, let me double check because for some reason my notes say that no return is on file.
Okay.
Judge, on this particular case, going over the docket, I did notice that it does say that the return was on file, but it is blank.
Okay.
Okay, we'll have to fix that then, Your Honor. We apologize.
Okay, I can give you a short reset.
Okay.
And then, let me see. Let me just double check that I'm going to, let me pull up my calendar. Okay, I can just give you a quick reset to June the 23rd.
Your Honor, I have a doctor's appointment that day, I believe in the morning. I apologize.
Okay,
Can we make it the 30th?
we sure can.
Okay, very well. Thank you.
So we'll come back on June the 30th at 9:30.
Very good. Thank you, Your Honor. We'll fix that problem. Sorry.
Okay.
Thank you very much. May I be excused.
Yes, you may.
Thank you, ma'am.
Thank you. Okay, Attorney Damian Orozco?
Good morning, Your Honor. Damian Orozco here on behalf of Mr. Jesus Oyuelas, Your Honor. And that's on cause number CL 190948I. Opposing counsel is Ms. Erica Ramirez, Your Honor.
Okay, and is Ms. Ramirez on?
Yes, Your Honor. I saw that she is on.
Okay, that's number 23 on the court's docket. And what are your announcements, counselors?
Your Honor, this case, we mediated yesterday with Ruben Ramirez. He gave us a mediator's proposal, which we are currently attempting to see if we can accept.
Okay,
That is correct, Your Honor. I did receive a copy of the mediator's proposal yesterday. I conferred with my client, Your Honor, and we'll be sending a response today, Your Honor. And I believe he gave us a deadline of Friday.
okay. So do you want to, well, we can come back for a second status on August the 25th.
August 25th, Your Honor?
And then at that time, you can let me know which way you all want to go.
Will do, Your Honor.
So we'll do that for August 25th at 9:30.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, anything else?
Nothing on our behalf.
Okay,
May we be excused?
you certainly may.
Stay safe, Judge.
Thank you, likewise. Okay, Attorney Robert Bettis?
Good morning, Your Honor. I have number 21 on your docket, CL 190200-I. Ocampo versus Garza.
Okay, and defense counsel is whom?
There is no defense counsel, Your Honor. We served both defendants and we set a hearing in order to see if we can get them to show up. So they'll give the citation to their insurance company so we can proceed forward and get an answer on file. They didn't show up, so now we're gonna have to file a default judgment and go that route.
Okay. Okay, let me just, Sarah Montiel and Roberto Miguel Garza. Anyone here on their behalf? Okay, so then Mr. Pettis, you'll be filing a motion for default judgment?
Yes, Your Honor.
Okay, just make sure that you attach the order setting hearing or file that also so that we can get you set. How much time do you need to file that?
I think we were pending some affidavits to prove up the default judgment, but 60 days should do it.
Okay. Then I'm gonna set up a tickler. Let me see. For August the 20th, just to make sure that it's been filed by that time.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, you may. Mr. Kennedy Salinas, can you hear me?
Your Honor, yes. Can
Okay,
you hear
what
me?
page are you here on? Yes, sir.
Yes, Your Honor. I'm on number 32 of your docket.
Okay, F 5397-19-9 in the matter of the marriage of Esteban Osuna versus Maria Luisa Osuna. And what is your announcement, counselor?
Yes, Your Honor. I have my client next to me. This case has been on for quite a while, Your Honor. We wanted to try to get it resolved. Mr. Sergio Munoz is on the other side, but we want to just move this. It's been a while. Their communication with both my client and also his wife. We just want to get this resolved, and we have sent proposals. We are not getting anything back, Your Honor. So we want guidance from the court of there are properties that are involved, and we have not received any type of response or anything, Your Honor, in this case. And it's already ripe for so we can conclude this case so both parties can move forward, Your Honor.
Okay, but such as, is it necessary for y'all to do discovery? Are you prepared to move forward with mediation? I mean, I have no way of knowing that.
Well, we have it. She cancels the mediation. She switched attorneys too. So I think it might be, she might be trying to prolong this as much as she can. She had Melinda Diaz before, we had a mediation set, we spent money on that, and then she canceled it that day. And then there is monies coming in. They have several investment properties with apartments, and then basically it's just been there. I mean, they get about 12 to 14,000 a month in investment properties. And my client's the one who maintains them. He's not getting any amount of that money at all since COVID. And we had an agreement that she's getting money from there so she can live. But basically, we need to just move forward. She started with Melinda Diaz way at the beginning. We were doing well. We did discovery. We sent ample discovery on my part, a ton of discovery. They got everything. Then we had mediation date. Boom, on the mediation date, she said, no, I'm going to fire Melinda Diaz. And then we lost money with mediation there too. Then she got Sergio Sanchez and said, no, I'm going to take over. It'll be good. I've tried with Sergio. He's a great guy. I have not received, we send the proposals. He has a ton of mediation because we already did all the mediation when he had Melinda Diaz. And then now we've done everything in this case, and my client wants to move forward with his life. And I believe hopefully the wife does too. But basically we're asking this court, what do we need to do? Because we want to go forward, spend more money in the mediation. And then she says, oh no, I'm going to cancel it or whatnot. So, and we send in a proposal, basically everything in half. Like it's nothing like, it's more for her benefit too. We have not received any response from Mr. Munoz's office. And I've been trying to call. He just responded barely. Yes, we're saying, yeah, we'll get your response. We haven't received anything, Your Honor.
Okay, well,
But
hold on. We just received a notice that he'll be logging on. So let him log in, and then that way we can talk about it. So give him a moment and I'll recall you shortly.
Yes, and thank you, Your Honor. And I'm very good working with different attorneys, and I just want to explain some so we can be there. Okay, Your Honor? Okay, thank you.
Okay, Attorney Monica Galvan?
Yes, Your Honor. I have number 28 on the court's docket.
Okay. That is CL 20-0050I, Norma Richmond versus Elgin's Investments et al. And do you have opposing counsel?
I don't see them on the screen, Judge. Monica Galvan for Norma Richmond. This is just a status. We had filed the DCC. We are moving forward with the case if the court just wants to give us a new date.
Well, who's opposing counsel?
I believe it's Damian Orozco, Judge.
Okay, Mr.
Hold on,
Orozco.
let me double check.
Okay.
If you want to give me a chance to pull that up, Judge, just so that I can make sure.
Okay.
And recall me, I'll double check right now.
Okay.
Okay, thank you.
Okay, Mr. Guerrero, I let Mr. Sanchez in.
I'm here, Judge. Good morning.
Okay,
Morning,
good morning.
Judge.
Okay, go ahead and let me recall your case then.
I think it's number 7, Your Honor.
Yes, I was looking. Let me see. Okay. Yes, F3450-09-9 in the matter of the marriage of Lorena de la Garza versus Alexi Ramos. Okay, counselors, what is your announcement?
Your Honor, this is Fabian Guerrero for Alexi Ramos. He should be present, Judge, in the meeting. This is our motion for enforcement regarding property that was awarded to Mrs. Lorena. We're ready to proceed.
And Judge, good morning. Sergio Sanchez on behalf of the petitioner. Your Honor, at issue here is her trying to refinance the home in her name solely. It's in both of their names right now. I know that's what Mr. Guerrero has been asking for, going back, I believe, to County Court 1, where we originated. She needs additional time, Judge. She's done everything to try to secure this financing. She's on limited income, and she's just having a difficult time with bank after bank after bank. We're just asking for time, Judge. She's not delinquent on the note. It's just, we need to get this gentleman off, and we know it. She's making every effort possible.
Okay, and how much time has she had already to try to refinance this?
Quite a bit, Judge. What we're lacking on our end, from my vantage point, is, I mean, I keep giving my client the same update that she's working on financing, but I've received no proofs of any of those efforts, Judge. It's been going on for almost north of a year and a half. And if something could be provided to us to see what the efforts were and what we can do to make it easier, I think if we work together, we can get this resolved. But there's no information coming as to the specifics of the efforts. And that's where it's troublesome.
Well, Judge,
No, but
Your Honor, happy to, and happy to provide that to Mr. Guerrero. And I would ask not for an extended reset, but for a brief, even if it's a 10-day or 1 week. So I could get all of the financial information over to Mr. Guerrero.
well, I think he's wanting denial letters or something to that effect to give, to see whether or not she really has any hope.
And if we can do anything on our part, Judge, I mean, we're willing to do it. Alexi doesn't, this is affecting his credit, his ability to buy his own home, things of that nature. And he wants to move on. I mean, this is a divorce that kind of, they're divorced, but on paper, but they still have this asset that's nagging at Mr. Ramos.
Okay, let me ask you, was there a set time frame in the divorce decree where
That's a good
she
question.
was supposed to refinance? Because I understand that she may have been ordered to refinance, but if there's no time frame, then what did you all do?
Then that's why we styled our motion in the form of clarification. I mean, is this something?
Well, the thing is like, look, when you don't put enforceable language in a divorce decree, it makes it very difficult for you to enforce it. And if you didn't put a cutoff date as to when she should have refinanced it, then that's your first hurdle. If you didn't put a contingency plan as to, okay, if you don't get refinanced with this amount of time, then we're going to sell it, that's your second hurdle. So it's kind of like, how am I gonna, I understand she hasn't refinanced it, even though she's been told to refinance it, and I can enforce that part, stating for her to refinance it. But when you don't put any kind of contingency things in place, such as after one denial or after two denials or after 90 days or 120 days, what do we do next? That's where it makes it difficult even for the court to enforce anything other than, okay, she needs to refinance it. Now, I mean, Mr. Sanchez, I would suggest also that you speak to your client and have her be honest with herself too. I understand how it is. I mean, I did it for 20 years almost, and they don't want to let go of a property because they've invested so much time into it. But if she cannot realistically refinance this home under her name, then it may be time for you to have a come to Jesus talk with her and tell her like, hey, you're not going to be able to get this home under your name. You need to let it go one way or another. Whether if you didn't have a contingency plan in there about selling it, then when she sells it, that's her money. And she can do what she wants with it because you didn't have anything in there to say that he gets half or anything like that. So something has to move on because it's not fair for him to have it on his credit report and he's not able to get a new home. And Ms. De La Garza also needs to decide at this point, what way is she going to go with the home and the refinancing? So if she's been on limited income and she's been denied several times, and the reality is that she's probably not going to be able to refinance it. Now, whether she's been trying with another person on the application with her, I have no idea of knowing. So, we can't let it go on forever, gentlemen. So we need to come up with something, and I don't mind having a hearing on this solely. And I'll be glad to hear from both of your clients and have them, put on testimony. Mr. Sanchez can put on some exhibits that she's tried, and Mr. Guerrero can put on some controverting evidence. Or I can give you an opportunity to talk it out by yourselves, amongst yourselves, to see what is it that they want to do.
Well, I'd like some more information, as I stated before, Judge. I think that'll give us a better perspective as to what's going on.
Okay.
We just have representations that there's efforts and no documentation.
Okay.
I'll provide that, Judge, as the court, I think, is hinting that I just need to get that over to Mr. Guerrero. And I will have that talk with my client.
Okay, well, because of the way that my court schedule is and my schedule, I'm gonna have you come back on August the 25th at 11 a.m., at which time that's my contested docket for the civil, which means if you don't have it worked out, please be prepared for a contested docket with witnesses and any exhibits that you want for me to review, have it filed prior to that time.
Thank you, Judge.
And that way we will come to some kind of resolution on that date.
Thank you, Judge.
Thank you, Judge.
Okay.
May my client and I be excused, Judge?
You certainly may.
Thank you.
Okay. Mr. Sanchez, I know you have something on the docket at 11, so you can
35.
be,
For 35, Your Honor.
yeah, you can be temporarily excused and come back at that time if you'd like.
If I may say, Judge, I don't expect the other side to show up on that one. I believe the gentleman was arrested yesterday for not complying with a visitation. The notes I have is that my client, well, the police were called and the guy was picked up, is my understanding. So I just wanted to point that out to the court.
Okay, and so he's still incarcerated at this time?
I believe so. That was just yesterday, Judge. So I can't imagine him being out yet.
Okay, and so are you going to be submitting an extension on your restraining order?
Yes, Your Honor, we are. I think that was submitted just a few days ago. So may have been June 4th.
Okay, I just signed it on the 4th. That is correct. Okay, well then, let me see.
Judge,
Yes.
if I may, Mr. Salinas did call in for the link. We did provide it to him. Obviously, this is way before that incident happened, but just so the record could reflect that it was provided to him.
Okay. Well, what I'll do then is let's just wait until 11, because since he called in for the link, and I mean, I'm not sure unless we can see that he's still in custody. We'll just recall it at 11.
Thank you, Your Honor.
Okay.
I'll check back, Your Honor.
Okay, Ms. Galvan?
Yes, Your Honor, I apologize. It's Mr. Fabian Guerrero, and I saw him on the screen, and I don't know why I didn't say his name. I don't know if he's still on, but discovery is still ongoing, so we're not prepared to go forward at this time.
Okay, no, Mr. Guerrero logged off.
I don't know if you want to give us a new date, a reset.
Okay. And do you have that, is Mr. Guerrero representing all the defendants?
I believe there's two defendants, the owner and his company. And I believe he's representing both, yes.
Okay. Then have you all concluded discovery?
No, Your Honor, it's not concluded at this time.
Okay. And then, so let me set you for a second status on September the 29th. And let's see at 9:30, and let's see how far y'all get between now and then.
I'm sorry, Judge, was that September or December? I didn't hear you correctly.
September 29th.
September 29th. Thank you, Judge.
At 9:30.
At 9:30. Thank you. May I be excused?
You certainly may. Okay. Mr. Garza, were you ready on your friendly suit?
Yes, Your Honor, we are present and ready. I see opposing counsel, Mr. Thompson on the screen. I would believe Ms. Canales is probably under, I'm guessing Attorney Juan, which I'm guessing is right. Oh, there's Melissa.
Good morning.
Okay,
Morning.
and this is number 1 on our docket?
That's correct, Your Honor.
Okay, CL 210677-I, Irma Garza Reina individually and as next friend of Yesenia Reina versus Billy Ray Scoggins et al. Okay, and what are your announcements, counselors?
Yes,
Judge Tommy Thompson for defendant Billy Ray Scoggins and Linda Scoggins. We're present and ready.
Judge Frank Gatsas standing in for Mr. Fidel Peña this morning on this friendly suit. Present here in the conference room is Mr. Gilbert Reina, father of minor Jacqueline Reina. I also have Ms. Irma Garcia and Michael Reina, parents of Destiny Reina and Desiree Reina, the other two minors, Judge. And we're present and ready for this friendly suit prove-up, Judge.
Okay, and who will be testifying?
The parents, which would be Mr. Gilbert Reina on behalf of Jacqueline, and then for Destiny and Desiree, would it be? Okay, it'll be Ms. Irma Garcia, Judge, and they both speak English, so we just need them sworn in, and then Mr. Thompson can ask questions.
Okay,
Perfect.
please raise your right hand, Mr. Reina and Ms. Garcia. Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may proceed.
I'm right here, folks, so you can see me, Mr. and Mrs. Reina, Mr. and Mrs. Reina. I'm going to try to do this as efficiently as possible, so I'll refer to Mr. Gilbert Reina, and then secondarily to Mr. Michael Reina. Okay, let's go first.
It's Irma Garcia.
So we can kill two with one. Is that okay? Okay. Mr. Gilbert Reina, would you please state your name and address and your spouse's name for the record?
Gilbert Reina, Yesenia Reina. It's 113 West Taylor, Harlingen, Texas, 78550.
And Mr. Michael Reina, would you do the same, please? Name, address, and your child's name and your children's names and your wife's name.
Tommy, I think Irma Garcia, the mother, was going to testify, unless you want Michael to answer that as well.
Irma is fine with me. You read their name, so that's what I was going on. Miss Irma Garcia. That'll make it even easier.
My name is Irma Garcia. My husband is Michael Reina, and the address is 318 West Gilmore Avenue, Harlingen, Texas, 78550.
And your two children are Desiree and Destiny. Is that correct, Miss Irma Reina?
Yes.
Okay, there was a little confusion earlier because their last names are all Reina. Are you all related?
Yes.
Yes.
Okay. I'm going to start with Mr. Gilbert Reina, but if you'll pay attention, Miss Irma Reina, to the question, that way we don't have to repeat it. Firstly, Mr. Gilbert Reina, have you spoken with your spouse about the settlement and approval of this, the terms that your lawyer has reached on your wife's behalf or your behalf or the kid's behalf?
Yes.
And are you in agreement with those terms?
Yes.
The same thing, Ms. Irma Reina, have you visited with your spouse with regard to the settlement terms, and are you in agreement? And have you heard that your husband was likewise in agreement?
Yes.
You understand, Mr. Gilbert Reina and Ms. Irma Reina, that this case is being settled, and this is we're asking the court to enter a final judgment that will end this litigation, and this is important, you will not be able to come back in the future for your little girl's claims, either one of the families, that this is, after the judge signs a judgment and it's finalized in 30 days, this is it. There's no more coming back and asking for more money. You understand that?
Yes.
Yes.
Do you understand that even if there's an ailment that hasn't been discovered as of yet, that can somehow in the future be related back to this accident, that you cannot come back?
Yes.
Yes.
Okay. Do you understand that this final judgment, once signed by the judge, can only be appealed for 30 days and then it is written in stone, correct?
Yes.
Yes.
Okay. Now, how are the children doing? How's your child doing, Mr. Gilbert Reina?
She's doing good, sir.
Okay. And how are your two daughters doing, Miss Irma Reina?
They're doing good.
Okay. Have you had an opportunity to review the settlement documents with your attorneys?
Yes.
And have you had an opportunity to view them with the ad litem attorney, Ms. Canales?
Yes.
Okay. Has your attorney explained to you how the fees are going to be dispersed, including that the monies are going to be deposited for the girls in the registry of the court in an interest-bearing account?
Yes.
Yes.
Okay. And that is all the money that will ever be deposited. You understand that, correct?
Yes.
Okay. I repeat that because it's very important that you have that knowledge and understanding. Now, the children are receiving monies that's being deposited with the registry of the court in an interest-bearing account, and that is their money. Do you understand that?
Yes.
That you will not be getting any of the children's money that's been designated in the settlement and has been incorporated into the final judgment we're going to propose to the court if it's approved. You understand that?
Yes.
Any monies you'll be getting will be divided after the attorney is responsible for paying any and all medical expenses, hospital liens, or healthcare provider liens. Do you understand that?
Yes.
The money to the girls is going to be put in the registry of the court in an interest-bearing account until the girls are 18 years old or upon further order of the court for good cause shown. Do you understand that?
Yes.
You will not be able to touch it, correct?
Yes.
Correct.
Okay. You are settling a disputed case. Nobody's admitting to any liability here. We're doing this to buy peace. Do you understand that we are settling a disputed case on behalf of Mr. and Mrs. Scoggins?
Yes.
Yes.
We're also settling the disputed case on behalf of any of their heirs, officers, agents, their insurance company, anybody who's related in any way, shape, or form to Mr. Scoggins or Miss Scoggins as a result of this accident. You're giving up any potential causes of action or claims for the future after this, if approved. Is that correct?
Correct.
Yes.
You understand that, right?
Yes.
Okay. Have you had an opportunity to review and have any questions regarding the release of the liability explained to you?
Yes.
Have all of your questions regarding the settlement and the finality of a potential judgment been explained to you clearly?
Yes.
Yes.
Do you have any questions right now of me?
No.
Okay. You understand that if your attorney fails to pay any of these liens, you will ultimately be responsible for the healthcare provider's costs if they're not paid directly from your attorneys as has been agreed to. You understand that?
Yes.
Do you believe the settlement's in the best interest of your children?
Yes.
Are you asking the judge to enter the a final judgment per the terms of the agreement reached and negotiated by your attorney with my office and with the insurance company and potentially approved by Ms. Canales?
Yes.
You're asking the judge to enter that, correct?
Yes.
And that will conclude the matter as we've discussed. Have you reviewed the outstanding liens and hospital bills and attorney's fees with amounts that will be going towards your individual claims?
Yes.
Yes.
And are you satisfied with your attorney's representation?
Yes.
And are you happy with the representation of your children given by Ms. Canales?
Yes.
Yes.
Have you had an opportunity to meet with her in person?
Yes.
Judge, I'll pass the witness. Thank you.
Okay, Mr. Garza, do you have any questions?
No questions of the witnesses. Mr. Thompson covered all aspects of it, including representation by Mr. Peña's office. So pass the witness to Ms. Canales at this time, Your Honor.
Okay, Ms. Canales, do you have any questions?
Yes, I do, Your Honor. To the parents of Desiree and Destiny, I did meet with your children, is that correct?
Yes.
Okay, and my office did have the opportunity to review all the medical documents and also make sure that everything was reduced and everything is, as far as we can see on paper, everything is in the best interest of your children. Are your children doing okay at this time?
Yes, ma'am.
Do they have any residual injuries from this accident?
No.
No.
Okay, I pass the witness, Your Honor.
Okay, any further questions from anyone?
No cross, Judge.
I just want to add, Judge, that we've already emailed the settlement documents to Mr. Thompson's office, so for him to be in the lookout. I mean, Ms. Canales, to both of them. So, but if they need anything else of us, Judge, let us know. And we're requesting approval of the settlement.
Your Honor, I I'm sorry, I have reviewed all the documents, Your Honor, and everything, I approve of everything, Your Honor.
Judge, the only issue that remains outstanding is that of compensation with Ms. Canales. I have been in contact with her. We've received correspondence and exchanged calls. There's been no agreement reached yet. We can probably reach an agreement, but as of this point in time, I don't know the totality because we've been reset 4 times, or 3 times rather. This is the 4th hearing. And I'd like an opportunity to visit with Ms. Canales to see if we can't reach an agreement with regard to ad litem fees.
That's fine, Your Honor.
Okay, I'll give you an opportunity to do that. And so, because without that, you wouldn't be able to submit the
Final decree.
final order.
Judgment.
So I'm gonna give you a short time period to get that done. And so I'm gonna set a tickler for June the 25th to see if that's already been submitted. And if not, then I'm gonna set you up for a show cause.
Yes, ma'am. Judge, if we are not able to reach an agreement, I will have a contested hearing with cross-examination pursuant to the Arthur Anderson standards. I don't anticipate that. I'm just telling the court that in addition to show cause, we'll need to put on some testimony. I don't anticipate it and I don't want it, but.
I hope not.
I hope not.
Because, you know, let's try to work that out. This is, you know, and also to extend professional courtesies
Yes,
to
ma'am.
one another. So
I agree,
okay.
and I know she's been diligent in her representation of the children and in her correspondence to both Mr. Pena and myself. We don't have a figure that's been bantied about or any.
Your Honor, I'll be reasonable, Your Honor. I'm not gonna try to strike it rich off of this case, Judge.
I tried to, but I couldn't, so.
Okay, then the court will accept the agreement as read into the record and ask for the ad litems and take the ad litems suggestion, and I will approve the settlement. And I will, like I said, set a tickler for June the 25th to see if the document has been submitted with all party signatures on it.
Yes, and the other thing, Judge, is the checks were reordered because there was a misidentification of the parents of Jacqueline in the original petition. That's why it was amended. The checks I called as recently as 9 o'clock this morning, left messages with the adjuster, so they should be on their way. They had to be redone because of the mistake with regard to who the proper next friend of the child was, Jacqueline.
Okay.
So hopefully I'll have them by tomorrow, overnight.
Okay. All right. Well, then hopefully you all will get all of this worked out and then it'll end there.
Yes, ma'am. That's my hopes.
Okay. All right.
Thank you, Judge.
Anything else?
Not from the plaintiff's, Judge. Thank you very much.
None from the defense, Your Honor.
Okay.
Not from the ad litem. Thank you, Your Honor.
Okay, everyone is excused unless they have another announcement on another case.
Thank you. Goodbye. Have a good day.
Likewise. Okay, iPhone. Who's on iPhone with the blue cap? You need to unmute. Yes, take your cap off. Thank you.
Yes,
Okay, what is your name, sir?
Edward Ramon.
Okay. And who is your attorney?
They said they were gonna provide, sorry. They said they were gonna provide one for my insurance. I'm not sure what his name is.
Oh, Mr. Ramon, your case, you do have one. They filed a Rule 11 on your case, which means that they are not proceeding on their motion for default judgment. If they need to, they'll file another order setting hearing and you'll receive notice.
So that means, am I out of this or I'm still going through it? I'm not
No,
sure.
at this time, you're still going through it, but you're relieved of it for today.
And what about the statute of limitations? Isn't it 3 years already?
I can't give you any advice on that, sir.
I see. So as the moment, we're just dismissed today and going forward?
Well, for today, what they were gonna have on the docket, which means before the court, is not moving forward today after all.
Okay, because the thing is that the truck there was an accident, the truck had insurance, but the insurance don't want to cover. But I guess they have to deal with that, right? Not me?
I can't tell you, sir.
Okay.
I'm
Then I
sorry.
guess That's fine, ma'am. Then I'll wait for another paper.
Okay, thank you for appearing today.
Yes, ma'am. Thank you.
Okay. Mr. Ramos, I think I already called your case. Juan Ramos? Okay. Attorney Rene Reyes?
Your Honor, I apologize.
Rene Reyes, Judge, but I heard somebody else talk.
Yes, it's because I was waiting for Mr. Ramos to respond. Okay, Mr. Ramos, what case are you here on?
Your Honor, I'm here on, I have a case with Miss Patty Love, number 34 on your docket, but I'm currently in the 139th at this time.
Yes, Miss Love already made an announcement for you. She said that your temporary orders were e-filed, so I'll sign off on them.
Bye, Mr. Ramos. Have a good one.
Take care of yourself.
Thank you, Judge. You be safe.
Thank you.
Okay, Mr. Ramos, I'm not sure if you were talking to this judge or the other judge.
I apologize, Judge.
Okay, so Miss Love already made an announcement on your case. She said that your temporary orders were signed off by everyone and were e-filed. So we're requesting those to be forwarded to my queue and I'll sign off on them.
We'll do. I appreciate it. Thank you so much, Your Honor. I apologize.
That is fine. Okay, thank you.
Be safe.
Okay, likewise. Okay, Mr. Reyes, go ahead now.
Judge, I'm Rene Reyes. I represent number 4 on your docket.
Okay, F335320-9 in the matter of the marriage of Cesar Gonzalez versus Sonia de Leon.
Judge, I represent the petitioner Cesar Gonzalez. And as far as I know, there's no opposing counsel.
Okay, and are you ready to proceed with your final hearing?
Yes, ma'am, I'm ready to proceed. I got a few questions to prove up.
Okay, has Ms. De Leon already signed off on your decree?
No, Judge. She got notice and the letter was returned. It's on file. And she signed a waiver of service back in May 7th of 2021.
Okay, let me just look that up.
Thank you, Judge.
Judge, I hate to interrupt, but I've got another matter at 11.
Yes, I think I just saw your message that you have to be somewhere else at 11.
That's correct, Your Honor.
Okay, according to this, Mr. Reyes, it was returned because the notice was it said undeliverable.
That's correct, Judge.
So she doesn't have notice of today's hearing.
Judge, it's the same address that she placed on the waiver of service.
Okay. The thing is that on her waiver of service, she states that she wants to be notified when the case is taken up and considered by the court.
All right, Judge, then we'll have to track her down. Apparently she moved. That's the best information I have at this time. My client lost track of her. However, we'll do our best efforts to try to locate her, Judge.
Okay, so is her name Esmeralda or is it Sonia?
Sonia Esmeralda de Leon, Judge.
Okay, well, just so you know, Esmeralda is misspelled on the waiver. Okay.
Judge, let me ask you, if we find her, can she sign off on the decree and we'll submit an affidavit of approving up the divorce?
If she signs off on she wants to be notified. That's all.
Right.
That's what she
Understood.
stated. So she needs to be notified of the hearing. So you'll need to submit an order resetting hearing,
Okay.
a
we'll do
final
that.
hearing. And as long as her address matches the address that she put on the waiver of service,
Okay,
that's, even if it's returned undeliverable, that's all you're required to meet.
okay,
She says that she wants to be notified of the case when it's taken up, but she did not say that not to enter anything unless it had her signature on it. So if you give her proper notice and it's sent to that correct address, you just have to put it on the record that the notice went to the same address that is on her waiver of service. And then it just needs to be proved up by your client.
okay. Can we do it now, or we need to make another effort to?
No, you need to submit, you have to, well, I guess it would be the same thing, wouldn't it?
Right,
Okay,
The
and your
same
client,
address.
it's the same address.
that's correct, Judge.
It's because I can't tell.
Yeah, I couldn't either, but I read the top part of the stamp, and it looks like it's the same address that's on the waiver of service. They put that stamp right over the address. It says undeliverable, but right over it, and it's hard to read. You kind of see half of the address on top.
I do, the only thing I don't see is, I'm assuming that says Brownsville because of the B and the R,
Right.
but I don't know if the zip code is correct.
Well, let me try it again, Judge.
Okay. You may want to, I mean, I'm not telling you what to do, but you may
Right.
want to send somebody out there and just tape it to her door or something.
All right, we'll do that.
Okay. So just submit an order resetting final hearing on that, Mr. Reyes.
All right, Judge.
Okay, thank
Get
you.
it. We'll get it squared away. Thank you.
Okay, Mr. Brueggemann, what case are you here on?
Your Honor, I don't know the number on your docket, but it's Discover Bank versus Carl Scalise. Cause number CL200998I.
Okay, and you have opposing counsel on this?
Not that I'm aware of, Judge.
Okay, let me verify because I do see that there's opposing
Oh,
counsel.
and Andrew Smith.
Okay, CL 200998-I, Discover Bank versus Carl Scalise. I did have Mr. Scalise on the last time.
Here, Judge.
Oh, okay.
Okay, Mr. Scalise, who is, I'm sorry, or who said here, Judge? I can barely hear.
I'm here, Judge. I'm Carl.
Oh, okay. And who is your attorney, sir?
I'm not sure. I keep trying to get in communication with these people that are handling my debt consolidation. And last time, some attorney called me named Henderson, and he left me a message to call him back. And I've been calling back, and I'm not getting an answer or a call back from him. And I've been on the phone even this morning with Option One Legal, finding out what they're doing for me because I need to get this resolved.
Okay. Well, we're here for a status conference. Sir, Mr. Brueggemann, do you have anything else to add?
Yeah, I think we just need to move this case along. We've got a motion for summary judgment on file, so why don't we just get that set for hearing?
Have you filed your order setting hearing?
I don't believe, hang on. There was a proposed order in the system 4/30/21. I'm not sure if that's the one the court needs, but
No, it's the order setting hearing that I need.
okay, so you just need a fiat, okay.
Yes, I do. Okay.
Order
Once
setting
you
hearing.
submit that, then we'll go ahead and set that.
Okay, Judge, will do. Appreciate it.
Well, hold on. If not, then we're gonna come back for a status hearing on this on August the 25th
8:25,
at 9:30.
9:30.
Okay. Mr. Scalise, we'll come back on 8:25 at 9:30.
Okay,
Unless,
Judge.
unless their order setting hearing is filed before for the summary judgment.
Okay.
Your Honor,
Yes.
I apologize. In going over the case right now, on April the 7th, Attorney Andrew Smith did announce that the MSJ was moot. I am seeing it in the case summary. I'm not sure if counsel would like to reach out to that attorney.
Default move. I think Mr. Brett Scalise has made an appearance, but I'm not sure about the MSJ.
Okay, well, talk it over with your co-counsel and see what he says.
Will do.
Okay, thank you.
Thank you, Judge. May I be excused?
You certainly may.
Thank you very much. Appreciate it.
Okay.
Great day.
Thank you. And Mr. Scalise, you're also excused.
Thank you, Your Honor.
Okay, Ms. Salinas Ansaldúa?
Yes, Your Honor. I have an announcement on number 15 on your civil docket, P-0118-20-9.
Okay.
Judge, I had the opportunity to speak to opposing counsel, Albert Osorio, Judge, and we're agreeing to extend the temporary ex parte order for 3 months due to the pending felony pending indictment.
Okay. I had given you a previous setting on that for 8/25, is that correct? No.
I do not know, Judge. This case actually was transferred from County Court 1. This is my first appearance on this case. I don't know, that might have been another prosecutor, Judge.
Okay, so then you're gonna be extending it by agreement for 3 months.
Yes, with approval of the court, Judge.
So then why don't we come back on, let's see, September the 8th.
Okay. At 9:30, Judge?
September 8th at 9:30.
Thank you, Judge. That's all I have with this honorable court. May I be excused?
Okay, what did, on the other case, Jasmine Reyes versus Eric Garza, that's the one that you had the Rule 11.
Correct, Judge, and I'll be submitting that extension.
Okay. I think that's the one that I had given you the date to come back on August 25th
Okay, Judge.
at 9:30. Or how long did you all decide to extend that one for?
We just asked for an August setting, Judge, so August 25th works with both of us.
Okay. Okay, so that takes care of your cases.
Yes, Judge.
Okay.
Thank you, Judge. Good to see you.
Likewise. Okay, I did have let me see. Okay, there he is. Attorney Sergio Munoz Jr. Let me recall your cases, sir. I have
Yes,
Jesus Hernandez on CL 154397. Belen Gonzalez versus Chensi Chen. Okay. And what are the announcements, counselors?
Your Honor, this case was set, I believe, in trial in the referring court, and I believe it's set for June, so obviously it's probably not going to go. The only other concern, so we need to reset it, probably for status. The only other concern that I had was that we've been trying to obtain plaintiff's deposition for some time. And I'd like to see if we can't come to an agreement today regarding that matter.
Okay,
Judge,
Mr.
yes, Your Honor, that's fine, Judge. We can, I mean, I can work with Mr. Hernandez. We can do that within the next 30 days on my client Belen, and then I'm sure I'll just go ahead and ask for the depo, maybe this in the afternoon or something of his client, but I'm sure we can work it out to where we can do both in one day. And that might make things a little bit more efficient.
That'd be good.
Okay, and then after that deposition takes place, do you all have everything else like the discoveries are complete, almost complete?
I believe it's pretty much complete, Judge. We would have to then mediate the case.
Okay, and do you all want to agree on a mediator or do you want the court to?
We can probably agree to one, I believe.
Okay.
Yeah, that's fine, Judge. We can do the depositions and then I'll talk to Mr. Hernandez on the mediation.
Okay, then why don't we do this? Go ahead and do your depositions and by agreement within the next 30 days of both clients. And then you can set your mediation after that. If you can't agree to a mediator, go ahead and let us know. And you can submit your order of referral and I'll assign a mediator to it. And then come back on September the 29th for a second status to let us know whether it's been settled or if you're going to want to be placed on the court's trial docket.
That's agreeable, Judge.
Okay,
That's fine, Judge. On the 29th at what time, Your Honor?
9:30, sir.
All right, thank you, Judge.
Yes, sir.
That's all I have, Judge. May I be excused?
You certainly may. Okay,
Thank you,
Ms.
Judge.
Munoz, I do have Attorney Kennedy Salinas, who was on the other side on another matter that you have. Let me
Yes,
read
sir,
all that case. And that is F 5397 199 in the matter of the marriage of Esteban Osuna and Maria Luisa Osuna. Mr. Salinas, are you there?
Yes, Your Honor, can you hear me, Your Honor?
I certainly can, sir.
Yes.
Okay. I just need to know, will you all be agreeing to mediation? Where are we as far as the discovery are you all ready to mediate this?
Judge, I'll go ahead and respond, Judge, just because it's been kind of on my end in terms of getting back to Mr. Salinas, Your Honor, and that's my fault. I'll take responsibility on that. He did send me a proposal in regards to some of the properties that are owned by the parties, in addition to I think the residents that they have. I am gonna send him a response to that by the end of the day today, Judge. To me, it seems that maybe if I just work a little bit on that conversation with him, we should be able to agree. I think initially both parties were willing to work together on it, but that's just my announcement, I guess, from my end, Judge, in terms of me not getting back to Mr. Salinas within a more certain time.
Yes, Your Honor, if I may, Your Honor?
You may.
Yes, Your Honor, yes, if I could get that by today, Mr. Munoz, my client is right here, but we're asking if we could have a setting, Your Honor, if this doesn't work with that, we sent an ample discovery with the prior, with Ms. Diaz, and then obviously it got Mr. Munoz has it now, so we're ripe to try to finish this case. Both my client and his wife are in talking terms. They just have a lot of properties. They really do. And they are good investments. So there is money coming in. And we were very, we also said, she needs to, have support. If she's getting a good amount of money, my client's not getting anything. We just want to finish this case. If you could give me that, but can we have a date, Your Honor, just another status? So we can just, I think with the status, it's helping to move this case along. So
That's fine, Judge. I agree with Mr. Salinas, Judge. That's fine. If you want to give us another date, a short
If we
status
don't do
date.
it, then we can have them, you can enforce the mediation, Your Honor.
Okay, well, what we'll do is, I'm gonna give you all 14 days to talk out the proposal and see where you all wanna go, and I'll set you for a second status on June the 23rd at 9:30.
Okay, that sounds great, Your Honor.
And then from there, we can take it step by step.
Thank you, Your Honor. Thank you.
Thank you, Judge.
Mr. Munoz.
Yes, sir.
Can you please give me that today at the end of by this
Yes,
afternoon?
it'll be this afternoon. I'll email it to you.
Thank you.
Thank you.
Okay, anything else?
No,
Nothing
Your Honor,
further,
my
Judge.
excuse.
You certainly may.
Thank you.
Judge. Might be excused too, Judge.
Yes, you may.
Thank you. Have a good day.
Yes, you too. Attorney Lindsay Guerra?
Thank you, Your Honor. Good morning. I am here on number 18, Rodriguez versus Gutierrez Perez. It is now what is left in your court is Rodriguez versus Geico, and I'm attorney for defendant Geico. I don't believe that anyone for Mr. Mount's office has ever appeared this morning unless the court sees an attorney on here.
Your Honor, I'm here for Ms. Rodriguez. Yuri Sejas here on behalf of Mr. Mount.
Mr. Sejas is here to make that announcement.
Perfect, perfect. Sorry, I
Okay.
didn't notice the Dale inclined by his name.
And Your Honor, just so the court understands, right before this case was transferred to your court, there was a motion to lift a stay and abatement. The cases had, basically, there's several different lawsuits that were filed, or causes of action, I should say, that were filed. They were severed. There was a motion to abate that was granted until the underlying lawsuit was finished. The underlying lawsuit has since finished, and right before the case was transferred to your court, we filed a motion to lift the stay and abatement of the case back in December. That has not, at least I'm showing there, that has not been signed yet. We need to get that signed so that we can proceed with getting this thing taken care of and getting a trial date.
Okay. Okay, any other additional announcement?
No, Your Honor, we had earlier filed a motion for summary judgment in the first court, but yeah, while it's been stayed, we haven't been able to do anything on this. So if we could just get that lifted, and then we'll start moving this case along.
Okay, then I'll request that to be forwarded to me. Okay, well, I'm gonna want a second status on this. So how long do y'all think you'll need to give me a good second status?
Until the stay is lifted, Judge, we can't do anything. I mean, we need that order signed. I believe the order's already been submitted to the court, just needs to be signed.
I know that, but once I find that, how much time do y'all need to give me a good second status?
I think let's do 60 days, Your Honor, assuming that the order is signed soon, and that'll give us a little time to get up to speed and see if we really need to do any discovery or if we can just move right on to a motion practice on it.
Okay, well, because of my schedule, what we'll do is come back on September the 8th at 9:30. And once that is signed, and that should give you plenty of time to be able to come up with a plan as to what you're gonna do next on this.
And Your Honor, on the 8th, there will just be a status hearing because we did file a motion for docket control conference, I believe.
It'll just be a status hearing because by that point I should know when I can start giving dates for trial settings, and that'll go along with DCCs.
Perfect. Thank you so much, Your Honor. I don't have any further business from the court. May I be excused?
You certainly may.
Thanks.
Thank you.
Okay, thank you. Where are we? Okay, Mr. Mark Clem.
Yes, ma'am.
Okay, Mr. Clem, is your wife going to be on this morning?
I believe she is.
Okay, is that Joanne Clem?
Yes, ma'am.
Okay, and are you ready to proceed on your divorce?
Yes, ma'am.
Yes, ma'am.
Okay, give me one moment. Okay, so I do see that a proposed order of the final divorce decree has been submitted. There are just some minor things that need to be updated. Because there's some boxes you checked off that shouldn't have been checked off, but with your permission, I'm going to mark through those, okay?
Yes, ma'am.
Yes, ma'am.
Okay. So, I see that both of you have signed off on this, is that correct?
Yes, ma'am.
I'm sorry, ma'am. I didn't understand you.
You both have signed off on the decree?
Yes, ma'am.
Okay.
Yes, ma'am.
Let me see. Let me have both of you raise your right hand. Raise your right hand. You swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Mr. Clem?
Yes, ma'am.
Ms. Clem?
Yes, ma'am.
Yes, ma'am, I affirm.
Okay. Now, you, Mr. Clem, you are the one that filed for this divorce, is that correct?
Yes, ma'am.
And at the time that you filed for divorce, had you been a resident of Hidalgo County for at least 90 days and a resident of Texas for at least 6 months?
Yes, ma'am.
Okay. And you and Ms. Clem were married on September 9th, 2007, is that correct?
Yes, ma'am.
And what date did you stop living together?
July of, about the time that this was filed, June and July of 2019.
Okay. And you are asking for a divorce today because your marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of your marriage relationship. Is that correct?
Yes, ma'am.
In other words, you two at this time are not getting along. Is that correct?
We're getting along as friends, but that's to the extent of it.
Okay. And at this time, is there any reasonable expectation for reconciliation, sir?
No, ma'am.
Okay. And is your wife currently expecting a child?
No, ma'am.
And you and your wife do not have any biological or adopted children together. Is that correct?
Yes, ma'am. That's correct.
Okay. And do you and your wife have any community property together?
No, ma'am.
And you are stating that any debts that are under your name, you're going to be responsible for, and any debts that are under her name that she'll be responsible for. Is that correct?
Yes, ma'am.
Okay. And Ms. Clem, you are asking for a name change to Gomez?
Yes, ma'am.
And was that your maiden name or what is Gomez?
Yes, ma'am, that is the name that I had before I married Maury. I was actually married before for over 20 years, and that's the name that I've carried for most of my life. So that's the name that I would like to go back to.
Okay. And did you have an opportunity to read the divorce decree?
Yes, ma'am.
And are you asking the court to accept that divorce decree?
Yes, ma'am.
And the court will grant your divorce and the relief as requested by the parties and set forth in further detail in the divorce decree that was submitted to the court. I'll ask for that to be forwarded to me, and I'll go ahead and sign off on it.
Thank you.
Okay.
Thank you, ma'am.
Best of luck to you all.
Thank you.
Thank you, ma'am.
God bless you.
Thank you. Likewise.
Thank you.
Okay, do we have anybody?
I can sign off?
Yes, you can sign off and Mr. Clem can sign off. Okay, do we have anyone here on F 4121-19-9 in the matter of the marriage of Gabriela Flores and Ramon Flores? I see Mr. Ramon Flores is on.
Yes, ma'am, I'm here.
Okay, Mr. Flores, are you still represented by Attorney Jonathan Ball?
Yes, ma'am.
Okay, and I did see Mr. Davis on earlier, but he's not on anymore. Okay, I'm gonna go ahead and see if someone from my staff can contact them to see if they can find out if they're gonna be coming back on. So if you can just
Okay.
wait for me.
Yes, ma'am.
Steve, on this one in las notes no tenía $2,500
Okay.
deposit.
And do we have anyone here from CL 187062-I Midland Funding versus Manuel Huaracha?
Sonita took my tape. Can you take this, please? From now on, use them in your.
Your Honor.
Okay, yes.
If we go back to number 8, I just checked on the Odyssey. They filed a Rule 11 at 10:59 this morning.
Okay, please notify them that they need to make an appearance.
Yes, ma'am.
That is too late. I need somebody on. Mr. Flores has been on from the beginning. They owe him that courtesy. Okay. Anyone here for Midland Funding versus Manuel Huaracha? Okay, I'm gonna reset that for 8:25 at 9:30, please. And what about on number 24, the court's docket? Was anything filed by the party CL 191562-I?
Yes, ma'am. On number 24, I am showing that a Rule 11 was filed yesterday.
Okay, reset that to 8:25 at 9:30. I think for the future, I'm not going to allow Rule 11s on status conferences, or else I'm never going to know what's happening on these conferences.
Yes, ma'am. It was late. It was filed pretty late, Judge, at 3:50.
Okay, anyone here on Carelli Jalen Castañeda?
Yes, ma'am.
Okay, Ms. Castañeda, we were pending your fingerprints to be produced.
Yes.
And did you get that done?
Yes, ma'am.
Okay, let me check to see if it's from the proper agency. Okay. Okay, Ms. Castañeda, I do see that you filed your, let me see. The report has been received from the state. And you filed a pro se petition, is that correct?
Yes, Your Honor.
And this is for your daughter, Carelli Jalen Castañeda, is that correct?
Yes, ma'am.
Okay. And the reason that you, go ahead and raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. I swear to say the truth.
Okay. Ma'am, and you filed this petition for a name change on your daughter, who is currently named Carelli Jalen Castañeda, is that correct?
Yes, Your Honor.
And you are, and your daughter right now is 11 years old?
Yes, ma'am.
You need to leave yourself unmuted because I'm going to ask you several questions. It's okay if the baby's crying, don't worry about it.
Okay.
As long as my court reporter can hear you, don't worry about it. It happens. Okay. And your daughter is 11 years old, is that correct?
Yes, ma'am.
Okay. And you are requesting this name change because your daughter, the biological father is deceased, is that correct?
Yes, Your Honor.
And prior to the biological father being deceased, your daughter did not have a relationship with him, is that correct?
Yes, ma'am.
And your daughter has only known you to be her parent, is that correct?
Yes, Your Honor.
Okay. And your full name is?
Carla Licerio?
Okay. And you're asking your daughter's name to be what?
Kareli Jalen Eliserio.
Okay. And so that's Kareli, Kareli, middle name Jalen, Jaelyn, and last name Eliserio, Eliserio. Is that correct?
Yes, Your Honor.
Okay. The court will take judicial notice of all the documents in the court's file, and given the reason and the circumstances under which the petition was filed, the court will grant your name change request. There's an order that you filed back on March the 31st. I'll ask for that to be forwarded to me. And that way, if it is correct, I'll sign off on it. And if something's wrong, we'll let you know.
Okay. Thank you, Your Honor.
Okay, thank you.
May I be dismissed?
You certainly may.
Thank you.
Okay, thank you. Okay, do we have anybody here on Julissa de Leon Sanchez and Jose Angel Montreal? I believe those parties were pro se. Did the notice get mailed to them?
I see a Julissa on, Judge. Let me see if they provided their email. It was sent to them on April the 30th, Your Honor.
Mr. Davis, I'm going to go ahead and recall your case, sir. That is F412119-9 in the matter of the marriage of Gabriela Flores and Ramon Flores.
Tim Davis for the petitioner, Judge.
Okay, Mr. Flores is on. I do not see Mr. Ball on. I know that you all filed a Rule 11 less than 30 minutes ago, which I'm not accepting, so I need an announcement on this, Mr. Davis.
Well, again, Tim Davis for the petitioner. This is the case, Judge, where we have a mediated settlement agreement with the exception of one issue, and that was the characterization of the marital residence. So the judge had ordered us to file briefs with the court by May the 19th. I filed petitioner's brief on that day. Mr. Ball contacted me this morning that he needed until tomorrow to file his brief. I agreed to give him until tomorrow to do so.
Okay.
So that's where we're at.
Okay, so then we're gonna have a contested hearing on just that one issue. Is that correct?
Yes, ma'am. I assume so, yes.
Okay, then we'll do June the 30th at 11.
Okay.
If you have anything that you need for me to look at as far as exhibits, make sure that they're filed before then.
Yes, I know with my brief, I did include a couple of exhibits. I assume Mr. Ball will do so as well.
Okay, then we'll take it up on June the 30th at 11 a.m.
11 a.m. Thank you, Judge. That's all I have. May be excused.
You certainly may. Mr. Flores, you may also be excused.
Thank you, Judge.
Okay, whoever's under Julissa, please unmute yourself. Julissa?
Ma'am, I believe they called this morning. They are Spanish speaking.
Okay, well, they should understand Julissa. El nombre que está nombrado Julissa. Okay, Ms. Olivares, on F 5857-16-9 in the interest of Marcus Castro, we were notified that Mr. Garza is in mediation at this time. Are you making the announcement on behalf of both of you?
Your Honor, good morning. You were going to enter a ruling, Your Honor, and we did submit our letter briefs on April 14th. Each one of us, let me see, 20. Mine was on April 13, 2021, and his was on April 14, 2021.
Yes.
So that's all we need.
I had requested a status because I wanted to discuss some issues.
Oh, I see.
Both of you that had arisen. However, I do need Mr. Garza present for that.
Okay, Your Honor. I didn't know. I wish he would have reached out to me. I've been sitting here, you know, at like 9:45, and that would have been better, but I understand the court, and actually I enjoyed listening to you, so I'm okay.
Thank you. Okay. Well, can
Other
you?
date?
Yes, I'm gonna have you all come back on June the 30th at 11. And can you please let Mr. Garza know that his presence will be required, and if there's a conflict and doesn't allow either one of you to be here at that time, call us so we can set a time where both of you can be present.
Okay, I will do that, Your Honor. Does the court want to send us like, or your staff send us the questions we need to answer? Maybe we can do it through a trial exhibit, and then you can make a ruling, or you rather have a status hearing?
No, I need to discuss some things with y'all. I already have a ruling that I'm going to make.
All right.
However, I do need some clarification on some things.
Okay, Judge, then I'll let him know the new next date.
Okay.
And thank you. You have a wonderful day.
Likewise.
Thank you.
Okay, the last cases that I have are contested matters, so I'm gonna go ahead and start with CL 20 259I, Susana de la Rosa versus Fernanda Quintanilla et al. Counselors?
Good morning, Judge Javier Villalobos. Let me just walk out.
Okay.
We're in a mediation. 3 of the attorneys were in mediation today together, Judge, that we had in your docket.
Wow.
Okay.
Okay, and where, just announcements for the record?
Javier Villalobos desde La Rosa.
Juan Molina for Maria Fernanda Quintanilla.
And Keith Livesay for assisting Mr. Molina.
Okay, and we had been having another attorney come on for BBVA.
Right.
Present today? I don't see them present, and she's been present at all the hearings. Has anybody
Right,
heard from her?
I haven't. I talked to her, Judge, but I believe she was aware of the hearing.
I mean, I'm pretty sure she was.
So, Judge, I don't know what the court wants to do, but we had filed a motion to transfer. I don't know if the court's going to consider it right now. I don't know if we had a date, but if not, we can try and get her to come back in a few days and hear the whole thing.
Okay, well, I mean, I did see your motion to transfer, and then I do know that we also have a motion for summary judgment that's being carried over.
Right.
Along with several other motions. But I'm sure that she's gonna have a position with your motion to transfer.
Correct.
So, I'm not sure why she's not here. She's been very prompt at all the other hearings prior to, unless anyone can tell me if she's called in. I don't think she's called into my staff.
Judge, there was a problem on this particular motion and the order setting hearings because neither Mr. Molina nor I actually got notice until we got the email blast from the clerk's office. So maybe that was sort of the issue, but our suggestion is going to be to postpone this until the summary judgment hearing. And there's also like people that are being served in the process of being served or have just been served. And so their answer date is not yet, but if we, the answer date should occur, after or before the summary judgment hearing. So I would suggest we just kick the can down the road until the summary judgment hearing, and then the court can address all the issues.
And I would agree with that, Judge. I had forgotten they did bring a few others. The bank brought in a couple of the other errors, so they haven't even answered. Now, Judge, the other thing, kind of like Mr. Livesay talked about, we a lot of times have issues getting our own stuff. So I'm asking, we just did in another case where we're doing it together, that the court order us to do everything certified mail. Every notice we file, everything we filed, that Mr. Livesay and I, Mr. Molina, do it by certified mail. Because for some reason we don't get the information, they don't get our information. So I'm asking the court And I think Mr. Livesay would agree.
Well, I think I will agree that we've had problems, but I mean, the certified mail part, it's up to like $5 a shot. And so, I mean, I think regular mail would suffice, but I will do whatever the court requires.
Judge, we've had a lot of problems. I understand it may be $5, but we've had a lot of issues that we don't get or they don't get. The safest route would be if we spend the $5 to get a certified mail. That way there's no doubt as to we received or not received any documents.
Mr. Molina, you were going to say something?
Part of the issue, Judge, is that's why we did the continuance, right? For 2 reasons, meaning for procedural and substantive due process, nobody really got notice, and 2 people just got served with the lawsuit, the 2 siblings. So it would make more sense, since we were already set for the 30th, to set everything on that date. And as far as the certified versus, it's just a matter of effective communication. I'm fine however the court feels more comfortable. That's why we had filed the motion for continuance, for 2 very practical reasons, that we just weren't, again, procedural and substantive due process, not just with us, but on the people coming in with presumptively new attorneys.
Okay, so I'm looking at the last person that was served, their answer date, the latest answer date that's coming in is June the 28th. So that's the latest answer date. At this time, your motion for summary judgment is set for June the 30th. Were you going to, is that motion for summary judgment, the substance that is in that motion, is that the only thing that you're going to ask the court to consider, or are you amending any part of that motion for summary judgment? And are you going to want for these people to be served with that motion for summary judgment? Because if that's the case, then that needs to be moved as well.
Judge, our motion for summary judgment doesn't have anything to do with these new additional people. The motion to transfer will. They have a dog in that fight, and so I don't think there's a need to serve them with the motion for summary judgment. There probably is a need to serve them with the motion to transfer, and there are the other motions that are set are particular to the plaintiff, and so we're not asking relief against these defendants, and so there's no need to serve them with those other motions at this time. We won't be seeking relief against those newly joined defendants.
Okay. So the latest answer date, like I said, was June 28th. And I agree with you as far as them needing to have notice of the motion to transfer. So I can't if their answer date is on the 28th, the motion to transfer, if I reset this to June the 30th, I don't know that they're gonna, they can choose to exercise that they're not gonna be ready for June the 30th. Are any of, do they know who they are seeking as a representation? Do y'all have, I don't even know if y'all would have communication with them or anything like that.
I do not, Your Honor.
Okay. Because I'm trying to be realistic with the settings on the docket right now, because I'm getting slammed really as far as the dockets. I'm stacking a lot. So, and I'm trying really hard to accommodate everyone, because now with thankfully us trying to get back into more of a regular routine, people are wanting their stuff set, right? So I'm thinking that the best thing that I can do, give me one moment. And you all do not mind having the motion to transfer and the summary judgment motion heard on the same day. Is that what I'm hearing?
Well, that is correct, Judge, but I think probably the proper thing would be to do the motion to transfer, because that way there's no issue. Then if it is transferred, then the other court can take it up and figure out what they want to do. But it'd be I think that's the first thing that needs to be taken up.
Well, I mean, that's fine, and we're gonna disagree with that the motion for summary judgment, it would resolve the whole, litigation as far as this court is gonna do, and if it gets transferred to the probate court, we're gonna be here or be litigating for the next 4 or 5 years. And then there's additional motions that we have filed against the, plaintiff, that those are not going to go away even with the motion to transfer, that those are sanctions motions that need to be heard, and they should be heard by this court, because it's the court that most familiar with this.
Okay, so then, look, the way that my calendar is then, I can set everything, but I would have to move everything to August the 23rd.
That's fine, Judge.
I'm fine with that, Keith. We just need to get everything heard and give everybody enough time to prepare.
Okay, so then, all outstanding motions would be heard on August the 23rd at 1:30.
Sounds good, Judge.
And so we'll go ahead and move that. But what I do need, for the sake of making sure that everyone gets noticed the way that they need to, I don't know if you all want to file your order resetting hearings until after the latest answer date to see if you have counsel on the other side, and that way you include them properly.
Okay, Judge.
I mean, I would think that that's going to be the easiest thing, because
Judge, that's an excellent suggestion. And as the only one who's filing these resetting orders, I will do that and wait until after the answer date to see if somebody appears.
Okay, so then once you get that, then that way we make sure that everyone is copied. And as far as whether you all want to send things to each other, certified mail, I mean, I don't think that I don't feel comfortable ordering you to do that. I think that, you have email, you have the regular mail, you have fax. There's a lot of different ways that you can do it. I mean, I do not know what anyone's situation is. I mean, it's up to you what kind of service you want to use to ensure that proper notice goes out. I mean, I'm going to leave that at the discretion of each attorney.
Well, Judge, I'll submit my stuff directly, of course, through the electronic filing, but I will also send it certified mail, because we always have that issue. So I will do it myself.
Okay.
It's up to them what they do.
That's fine.
Okay. So then that's what we'll do, Mr. Livesay, or whatever. And also, Mr. Villalobos, on your motion to transfer, just file your order resetting hearings after June 28th to ensure that everyone that's on the case gets proper notice. And then we will put the date on there of August 23rd at 1:30. Well, actually, you can put the date on there if you like, at August 23rd at 1:30.
Sounds good, Judge.
Okay. Judge, yeah, are you going to expect us to have mediated this matter before the August 23rd hearing or not?
Judge, I wouldn't even suggest mediation, because this is 25,000. The 250,000 are in probate court. This is very minimal. The issue is going to be over there in the probate.
Well, the thing is to be honest with you, just hearing what I've heard on my little short tenure on the bench, I think y'all are far apart anyway. So
okay, no, I didn't want to. I wanted to get that issue out of the way.
Yeah.
If there was going to be a problem or an expectation.
Okay. All right. Well, then we'll see you back here on August 23rd at 1:30.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. And we'll be excused.
Yes, you may.
Hey,
And
Judge.
Mina, look at JR. JR,
Yeah.
please get with Ms. Bella Olivares.
Yes, Judge, I am here. I was present at all times at this particular Zoom site. I apologize for not making an announcement earlier about it.
That's okay. She came on, but I do need you to get with her, because we reset your case to June the 30th at 11, because I do need to discuss some things with you also. I will need for both of you to be present.
Okay, Judge, that's good. June 30th, I'll make a note of it. I'll
Okay.
be on vacation, but wherever I'm at, I'll join in.
Well, I did tell her that if that date didn't work for both of you, I'm not gonna ruin your vacation. If that date did not work for both of you, to please let me know and we will work on a date that works for both.
Judge, Judge, I'm gonna be on vacation for almost 15 days. Please ruin part of it. I really would like to get back. So I don't mind June 30th, Judge. That's good.
I'll leave it to your discretion.
June 30th is good, Your Honor.
Okay. All right. Thank you, gentlemen. We'll see you soon.
Thank you, Your Honor. Have a good day.
Thank you.
Thank you. Have a good day. Okay. So then, did we ever have anyone show up? Julissa de Leon Sanchez, Jose Angel Monreal? Okay, we're gonna go F 2686-21-9 in the matter of the marriage of Lisa Rodriguez versus Saul Salinas. Mr. Sanchez?
Judge, thank you for recalling. Yes, ma'am.
Okay, and Ms. Rivera, you said Mr. Salinas had checked in?
Yes, Judge, he's under the Galaxy S20. I know that he was having some minor issues with the audio, but I did see him appear.
Saul Salinas, can you hear me? Saul Salinas.
Hello?
The little green square came around his Galaxy S20, Judge.
Okay, I think we lost the connection. Okay. Mr. Salinas, can you hear me? Okay, Mr. Salinas, it's a very bad connection, sir. I can't.
Hello?
Okay, Mr. Salinas, can you please turn on your camera?
Can you hear me?
Can you please turn on your camera?
It's on. It's on. I could see you.
I can't see you. Okay, now we lost him. Mr. Sanchez, he's coming in and out.
Your Honor, I don't mind a quick
Oh, there
reset.
it is. Okay, Mr. Salinas, please unmute yourself. Oh, he's frozen.
Yeah, can you hear me? Can you... Hold on. Can you hear me now?
Okay,
Can you hear me?
you're still breaking in and out. So if you want to just find a spot and just stop. Okay, sir, will you be hiring an attorney for this matter?
Yes, I need to see a could be scheduled so I can reach in a counsel.
Okay, so Mr. Sanchez, this restraining order was signed on what date, sir?
My records show June 4th, Judge, is when you signed it.
Okay, and so then this will expire on the 18th. And
Yes, ma'am.
then I'm gonna give you, Mr. Salinas, how much time
Yes.
do you need to get an attorney?
I just got the letter yesterday. So I need, I don't know, ma'am, probably couple of
Okay,
days. or
well,
something.
what I'm gonna do is I usually give about almost a month for you to get get an attorney. So what I'm gonna do is on the 18th, when it expires, Mr. Sanchez, please file an extension and I'll grant one extension and we will return on June the 30th at 11 a.m.
Yes, Your Honor. Judge, could the court please admonish him that although he does not have counsel, your order is in effect. That's the way I understand it. And I don't want to, I know the police were called yesterday on an issue of visitation, and your order was to be enforced. At least law enforcement understood that. I'm just not sure if Mr. Salinas understands it completely.
Okay, Mr. Salinas, you should have in your possession a copy of the restraining order and the petition that's been filed by Ms. Rodriguez. That
Fíjese que ya
restraining
nos
order,
volvieron a hablar, pero pusimos lo mismo y
it is a
nada.
court
Ahora tenemos que hacer otra cita
and so
otra vez.
you do need to abide by that court order. That order and there's going to be one extension to give you some time. That order will be in effect until you come back on June the 30th at 11 a.m. And by then, if you have an attorney, then we will decide whether or not that restraining order will become what we call a temporary injunction. Now, the
Okay.
sooner that you get an attorney, the sooner that Mr. Sanchez can start trying to see what can be done on this case.
Okay.
What I will tell you is usually what we've been doing is, Mr. Sanchez, when we see that opposing counsel has come on, I will send an order of referral to mediation. And so,
Understood, Your Honor.
okay, so, but other than that, we'll come back and sit on June the 30th at 11 a.m. Submit your extension when this first restraining order expires, and I'll sign off on that as well.
Thank you very much, Your Honor.
Okay, so if that's all you have, then you are excused.
And what about my son, ma'am?
Okay, so that's why you need to go ahead and get an attorney as soon as possible.
Okay, ma'am.
So that they can start working on possible what's going to happen during this time period, okay?
Okay.
Okay, now you need to make sure that you know what's in that restraining order because you are going to be held to it.
Does he have to leave though? Or
I can't give you any advice, sir. The only thing I can tell you is that you've been served with a restraining order. There is an order in there, and I would suggest that you get counsel, and they'll be able to explain it to you.
Okay.
Okay?
Okay, ma'am. Thank you.
Okay, thank you.
Can I be dismissed?
Yes.
Thank you, ma'am. Have a good day.
Okay.
Bye.
Okay, Ms. Rodriguez, thank you very much, ma'am. You are also excused.
Thank you, Your Honor.
Okay, so CL 211992-I, Sonia Lopez versus Sylvia Borrego, also known as Sylvia Martinez, and Mr. King is the trustee.
Juan Angel Guerra, Your Honor, for Sonia Lopez, Your Honor.
Morning, Your Honor. Jordan King on behalf of Sylvia Borrego.
Okay.
Your Honor, I read Mr. King plead to the jurisdiction, and since we are questioning title on my petition, he is correct that this court would not have jurisdiction regarding the issue of title. So I'm in agreement with him to go ahead and granted his plea to the jurisdiction, Your Honor. We'll be filing in district court.
Okay. Okay, in light of what has just been announced to the court, then the court will grant Mr. King the jurisdiction. I'll ask for that to be forwarded to my queue. I'll sign off on it, Mr. King, and it'll be sent to all the parties.
Thank you, Your Honor. I'll have that in your queue before the end of the day.
Okay, no problem. Thank you, gentlemen.
Thank you. Have a good one.
Have a great day.
You too.
Okay. Okay. And Ms. Borrego, you are also excused. Okay. So now we have Julissa, who I cannot get to. And Miss, okay, that's number 31 on the court. There we go. Okay, ma'am, can you please unmute? ¿Puede oprimar el micrófono?
¿Sí me escucha?
Sí. Ok, so ¿usted es Julisa de León Sánchez?
Sí, correcto.
Ok, por favor, si puede subir el volumen.
¿Me escucha?
Sí, perfecto. Un momento, por favor. No mueva
Ok.
nada. No mueva nada, ¿ok?
Oh, sorry, sí.
Está muy bien. Ok. So, Ms. Sánchez, ¿usted tiene comunicación con su esposo José Ángel Monreal?
No, ya tiene como desde el 2005 o 2006 que yo no tengo contacto con él.
Ok. Okay, so let me call F-2415-19-9 in the matter of the marriage of Julisa de León Sánchez versus José Ángel Monreal. Okay, Ms. Castaneda, please let her know that today was for a status conference hearing so that I can find out what's happening.
Mes de León, la cita de hoy es
Dígame.
para saber qué está pasando con el caso.
Okay. So tell her that I do see that she did this by citation by publication. Is that correct?
Y se hizo por el anuncio para el señor se hizo por publicación de periódico.
Sí, correcto.
Yes, correct.
Okay. The only thing is that I do not see the citation by publication that was submitted. I do not see a return on file.
Okay, lo que no se mira es que la publicación del periódico se regresó para la corte.
Sí, ellos lo mandaron.
Okay, but there's not anything in the court's file that says that it was run in a newspaper or posted in the courthouse.
Pero no hay nada en el caso que se regresó para la corte o que lo pusieron en el anuncio de la corte.
Ok, ¿qué necesito hacer entonces?
What do I need to do?
She needs to check with the clerk's office to see if it was ever, she has a lot of feedback because she's at the courthouse.
Judge,
Yes.
if you scroll down to the citation of publication filed on January 29, 2021, in those dates, it does refer to a return date, and it does in the attached.
Okay. What I'm seeing on that date is that there's nothing signed on the officer's return and it's not signed by the clerk. So that's a defective citation to use.
I'm sorry, Judge, on my end, it's on the second page. If you'd like, I can share the screen.
Let me see. Okay, so hold on.
I didn't fill out that information, Your Honor, solely because we didn't have that email for Ms. Lee.
Okay, so what date are you seeing it on?
On January the 29th, 2021, it states citation by publication, Jose Angel Monreal. If you click on that PDF motion or document, Judge, you scroll to the second page. I can share my screen, Your Honor, if that's more efficient.
Hold on. Okay, go ahead and see if it.
Yes, ma'am.
So this is the first page, Your Honor. This is the second page.
Okay, I don't know why I'm not seeing that. Okay, so then that has been returned, and it says that it's been at the on the monitor, or in the monitor.
Yes, Your Honor, and attached, it does have the monitor ad as well.
Okay. And then, so then what she needs to do, Ms. Castañeda, let her know that she has to file an order for an ad litem attorney to be assigned to her husband for the publication.
Ms. De León.
Dígame.
Lo que le falta es, necesita poner una orden para que se le asigne un abogado al señor por su publicación por el periódico.
Ok, ¿y tengo que venir a la corte y aplicar por eso o decirles aquí?
Es una orden que tiene que meter como sus previas órdenes.
Tell her because she's choosing to represent herself, I have to treat her as an attorney.
Ms. Sánchez, como usted se está representando usted sola, tenemos que tratarla como si fuera un abogado.
So I cannot tell her how to do the form, only that she needs an order to appoint an ad litem for Mr. Monreal.
Okay, so no podemos decirle qué es lo que haga, nada más decirle que le falta una orden para apuntarle un abogado al señor.
Ok, está bien.
So, but what I'm gonna do is I'm gonna give her a second status conference
Se le va a dar otra cita
on August the 25th at 9:30.
el día 25 de agosto a las 9:30 de la mañana.
¿Está bien?
He has it by then.
Y esperemos que ya para entonces la haya metido la orden.
Ok, bueno, gracias.
Thank
Does she
you.
have a better email for us, Judge?
I saw it on something, but she can.
¿Tiene usted correo electrónico?
Sí, claro que sí. Es Julisa. Punto de León. 7828 @gmail.
Okay, it's julisa.deleon7828
Punto de León. Julisa punto de León.
julisa.deleon.
Okay. Okay. Bueno, muchas gracias, ma'am.
Gracias a usted. Bye.